What's up, guys? It is the Bad Wolf. 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 What's going on? Howling mad, right? So we're going to be talking about 18 USC 3161 or time limits and exclusions. No, not Doctor Who time. We can't control time, or do we? Hmm. Anyway, so in this particular passage, I'm going to let the AI reader, read this through Cornell Law. So a shot goes out to them. This is considered fair use. It is on the open internets, the interwebs and whatnots. So, but what we've got going on here is that they, the system has a lot of things in place, a lot of tools you guys can use when dealing with your cases and whatever else. You are entitled to be treated fairly and properly. So if a time limit is hit or an exclusion is present, and most of these things are things you guys don't know about or think about, you can use that to get your case dropped or extended. But you have to know these things. Now, a lot of people just sit back and go, well, I'm just going to pay a lawyer $5,000 or $10,000 when a lot of this you guys could do yourselves. Or even if you know it, you can say, hey, lawyer, I believe under 18 USC 3161. Yeah, we've reached a time limit, and this kind of violates my Speedy Trial Act of 1976. I think it's 76. So yeah, I think we should put that in and say a motion to dismiss based on that, just like that. So sit back, relax, make some popcorn, enjoy yourselves, and gonna watch this wild random dog off of its leash walking around outside. That seems safe. I should probably go pet it. Nope, standing here. That looks like a mean dog. All right, so let's get that rolling, 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 rolling. How's everybody doing? Hopefully everybody's doing good. Make sure you guys are taking care of yourselves. Take time for yourselves, a mental day or mental time. Woosah, relax, get a massage. Um, have a spa day, which I haven't had that ever. So I'm gonna have to get that in there sometime. But take care of yourselves, guys, because no one loves you more than yourself unless you believe in, the powers that be out there, the big G. And with that being said, take it away, Sam.
18 U.S. Code Section 3161 Time Limits and Exclusions. U.S. Code. Notes. Previous, next. A. In any case involving a defendant charged with an offense, the appropriate judicial officer, at the earliest practicable time, shall, after consultation with the counsel for the defendant and the attorney for the government, set the case for trial on a day certain, or list it for trial on a weekly or other short-term trial calendar at a place within the judicial district, so as to assure a speedy trial. B. Any information or indictment charging an individual with the commission of an offense shall be filed within 30 days from the date on which such individual was arrested or served with a summons in connection with such charges. If an individual has been charged with a felony in a district in which no grand jury has been in session during such 30-day period, the period of time for filing of the indictment shall be extended an additional 30 days. C. 1. In any case in which a plea of not guilty is entered, the trial of a defendant charged in an information or indictment with the commission of an offense shall commence within 70 days from the filing date, and making public, of the information or indictment, or from the date the defendant has appeared before a judicial officer of the court in which such charge is.
Did you hear that? They have a 70-day limit. Now, I will say this in regards to somebody who I won't mention their name for confidential reasons, but their stuff went over 70 days. But what the judge did, because some of them are crooked, it said, well, I don't think you're competent to stand trial. You need to go get a mental health evaluation. Now, this is a tactic that they want to use, and I would have responded by, well, Your Honor, are you a doctor in health? No. Psychology? No. So what makes you think that I'm not competent? Now, you could swing this two different ways. You could have said, all right, well, if I'm not competent, then you can't charge me. I'm an idiota. I'm not clothed in your office. I'm private. And I'm not underneath your jurisdiction. You could play with that a little bit, but in general, when this particular person came back, it's like, well, the judge said to this person, you waived your ability for the Speedy Trial Act because of your competency. That's a lie. This person did not consent to it. They were forced into doing it. So it was done under duress so that she could try to waive her speedy trial. That's how these people play sometimes. It is dirty, but it is legal. But once you know the dirty part that they did, and it was done under duress, and you were forced or coerced, you can then use that in your motion and be victorious. But they have dates, they have times that they have to get these things done, or they're in violation, and you can use that. So let's keep going.
Pending, whichever date last occurs. If a defendant consents in writing to be tried before a magistrate judge on a complaint, the trial shall commence within 70 days from the date of such consent.
Whoa,
2.
whoa, 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 whoa. Hold up, Miss Lady. Did she say if you consent to the complaint? Because a complaint sounds kind of civil and not criminal. So you have to consent for certain things. Interesting. Nothing new if you've been watching my channel, but if this is your first time here, don't forget to hit that bell and subscribe. Thank you in advance. Let's get back to it, tribe.
2. Unless the defendant consents in writing to the contrary, the trial shall not commence less than 30 days from.
Whoa! Unless the defendant consents in writing to the contrary. I'm telling you guys, now you guys see and understand some of the tools I use in my success in these cases. This is why the lawyers get paid lots of money. So when you see these lawyers and you don't think they can get you off, oh well, not in the P. Diddy way. So don't go there. Don't do that. If you don't think they can get you out of what's going on, they absolutely can. But it's called a court for a reason. What happens on a court? It's a volley of back and forth between two different sides, judged by a third, supposed to be impartial. And they're not, but we'll leave that part alone for right now. Let's keep going. I'm giving you guys gem drops, so don't forget to support me on blacksite32.com or jameslovett.com or my other YouTube channel, the Badwolf Media channel, or James C. Lovett on TikTok. I'm on there as well.
From the date on which the defendant first appears through counsel or expressly waives counsel and elects to proceed pro se. D. 1. If any indictment or information is dismissed upon motion of the defendant, or any charge contained in a complaint filed against an individual is dismissed or otherwise dropped, and thereafter a complaint is filed against such defendant or individual charging him with the same offense or an offense based on the same conduct or arising from the same criminal episode, or an information or indictment is filed charging such defendant with the same offense or an offense based on the same conduct or arising from the same criminal episode, the provisions of subsections B and C of this section shall be applicable with respect to such subsequent complaint, indictment, or information as the case may be. 2. If the defendant is to be tried upon an indictment or information dismissed by a trial court and reinstated following an appeal, the trial shall commence within 70 days from the date the action occasioning the trial becomes final, except that the court retrying the case may extend the period for trial not to exceed 180 days from the date the action occasioning the trial becomes final if the unavailability of witnesses or other factors, resulting from the passage of time, shall make trial within 70 days impractical. The periods of delay enumerated in Section 3161H are excluded in computing the time limitations specified in this section. The sanctions of Section 3162 apply to this subsection. E. If the defendant is to be tried again following a declaration by the trial judge of a mistrial or following an order of such judge for a new trial, the trial shall commence within 70 days from the date the action occasioning the retrial becomes final. If the defendant is to be tried again following an appeal or a collateral attack, the trial shall commence within 70 days from the date the action occasioning the retrial becomes final, except that the court retrying the case may extend the period for retrial not to exceed 180 days from the date the action occasioning the retrial becomes final if unavailability of witnesses or other factors resulting from passage of time shall make trial within 70 days impractical. The periods of delay enumerated in Section 3161H are excluded in computing the time limitations specified in this section. The sanctions of Section 3162 apply to this subsection. F. Notwithstanding the provisions of subsection B of this section, for the first 12 calendar month period following the effective date of this section as set forth in Section 3163A of this chapter, the time limit imposed with respect to the period between arrest and indictment by subsection B of this section shall be 60 days. For the second such 12-month period such time limit shall be 45 days, and for the third such period such time limit shall be 35 days. G. Notwithstanding the provisions of subsection C of this section, for the first 12 calendar month period following the effective date of this section as set forth in Section 3163B of this chapter, the time limit with respect to the period between arraignment and trial imposed by subsection C of this section shall be 180 days. For the second such 12-month period such time limit shall be 120 days, and for the third such period such time limit with respect to the period between arraignment and trial shall be 80 days. H. The following periods of delay shall be excluded in computing the time within which an information or an indictment must be filed, or in computing the time within which the trial of any such offense must commence. 1. Any period of delay resulting from other proceedings concerning the defendant, including but not limited to a. Delay resulting from any proceeding, including any examinations, to determine the mental competency or physical capacity of the defendant. b. Delay resulting from trial with respect to other charges against the defendant. c. Delay resulting from any interlocutory appeal. d. Delay resulting from any pre-trial motion, from the filing of the motion through the conclusion of the hearing on, or other prompt disposition of, such motion. e. Delay resulting from any proceeding relating to the transfer of a case or the removal of any defendant from another district under the Federal Rules of Criminal Procedure. f. Delay resulting from transportation of any defendant from another district, or to and from places of examination or hospitalization, except that any time consumed in excess of 10 days from the date an order of removal or an order directing such transportation, and the defendant's arrival at the destination shall be presumed to be unreasonable. g. Delay resulting from consideration by the court of a proposed plea agreement to be entered into by the defendant and the attorney for the government, and h. Delay reasonably attributable to any period, not to exceed 30 days, during which any proceeding concerning the defendant is actually under advisement by the court. 2. Any period of delay during which prosecution is deferred by the attorney for the government pursuant to written agreement with the defendant, with the approval of the court, for the purpose of allowing the defendant to demonstrate his good conduct. 3. A. Any period of delay resulting from the absence or unavailability of the defendant or an essential witness. B. For purposes of subparagraph A of this paragraph, a defendant or an essential witness shall be considered absent when his whereabouts are unknown and, in addition, he is attempting to avoid apprehension or prosecution or his whereabouts cannot be determined by due diligence. For purposes of such subparagraph, a defendant or an essential witness shall be considered unavailable whenever his whereabouts are known but his presence for trial cannot be obtained by due diligence or he resists appearing at or being returned for trial. 4. Any period of delay resulting from the fact that the defendant is mentally incompetent or physically unable to stand trial. 5. If the information or indictment is dismissed upon motion of the attorney for the government and thereafter a charge is filed against the defendant for the same offense, or any offense required to be joined with that offense, any period of delay from the date the charge was dismissed to the date the time limitation would commence to run as to the subsequent charge had there been no previous charge. 6. A reasonable period of delay when the defendant is joined for trial with a co-defendant as to whom the time for trial has not run and no motion for severance has been granted. 7. A. Any period of delay resulting from a continuance granted by any judge on his own motion or at the request of the defendant or his counsel or at the request of the attorney for the government, if the judge granted such continuance on the basis of his findings that the ends of justice served by taking such action outweigh the best interest of the public and the defendant in a speedy trial. No such period of delay resulting from a continuance granted by the court in accordance with this paragraph shall be excludable under this subsection unless the court sets forth, in the record of the case, either orally or in writing, its reasons for finding that the ends of justice served by the granting of such continuance outweigh the best interests of the public and the defendant in a speedy trial. B. The factors, among others, which a judge shall consider in determining whether to grant a continuance under subparagraph A of this paragraph in any case are as follows. I. Whether the failure to grant such a continuance in the proceeding would be likely to make a continuation of such proceeding impossible, or result in a miscarriage of justice. 2. Whether the case is so unusual or so complex, due to the number of defendants, the nature of the prosecution, or the existence of novel questions of fact or law, that it is unreasonable to expect adequate preparation for pre-trial proceedings or for the trial itself within the time limits established by this section. 3. Whether, in a case in which arrest precedes indictment, delay in the filing of the indictment is caused because the arrest occurs at a time such that it is unreasonable to expect return and filing of the indictment within the period specified in Section 3161(b), or because the facts upon which the grand jury must base its determination are unusual or complex. 4. Whether the failure to grant such a continuance in a case which, taken as a whole, is not so unusual or so complex as to fall within Clause 2, would deny the defendant reasonable time to obtain counsel, would unreasonably deny the defendant or the government continuity of counsel, or would deny counsel for the defendant or the attorney for the government the reasonable time necessary for effective preparation, taking into account the exercise of due diligence. C. No continuance under subparagraph A of this paragraph shall be granted because of general congestion of the court's calendar, or lack of diligent preparation or failure to obtain available witnesses on the part of the attorney for the government. 8. Any period of delay, not to exceed 1 year, ordered by a district court upon an application of a party and a finding by a preponderance of the evidence that an official request, as defined in Section 3292 of this title, has been made for evidence of any such offense and that it reasonably appears, or reasonably appeared at the time the request was made, that such evidence is, or was, in such foreign country. I. If trial did not commence within the time limitation specified in Section 3161 because the defendant had entered a plea of guilty or nolo contendere subsequently withdrawn to any or all charges in an indictment or information, the defendant shall be deemed indicted with respect to all charges therein contained within the meaning of Section 3161, on the day the order permitting withdrawal of the plea becomes final. J. 1. If the attorney for the government knows that a person charged with an offense is serving a term of imprisonment in any penal institution, he shall promptly a. undertake to obtain the presence of the prisoner for trial, or b. cause a detainer to be filed with the person having custody of the prisoner and request him to so advise the prisoner and to advise the prisoner of his right to demand trial. 2. If the person having custody of such prisoner receives a detainer, he shall promptly advise the prisoner of the charge and of the prisoner's right to demand trial. If at any time thereafter the prisoner informs the person having custody that he does demand trial, such person shall cause notice to that effect to be sent promptly to the attorney for the government who caused the detainer to be filed. 3. Upon receipt of such notice, the attorney for the government shall promptly seek to obtain the presence of the prisoner for trial. 4. When the person having custody of the prisoner receives from the attorney for the government a properly supported request for temporary custody of such prisoner for trial, the prisoner shall be made available to that attorney for the government, subject, in cases of interjurisdictional transfer, to any right of the prisoner to contest the legality of his delivery. K. 1. If the defendant is absent, as defined by subsection H3, on the day set for trial, and the defendant's subsequent appearance before the court on a bench warrant or other process or surrender to the court occurs more than 21 days after the day set for trial, the defendant shall be deemed to have first appeared before a judicial officer of the court in which the information or indictment is pending within the meaning of subsection C, on the date of the defendant's subsequent appearance before the court. 2. If the defendant is absent, as defined by subsection H3, on the day set for trial, and the defendant's subsequent appearance before the court on a bench warrant or other process or surrender to the court occurs not more than 21 days after the day set for trial, the time limit required by subsection C, as extended by subsection H, shall be further extended by 21 days.
All right, guys, that's it. That is it. That is it. If it doesn't fit, you must acquit. All right. So the short story of this is that if they do not adhere to these rules, regulations, time constraints, you can use it against them. My rights have been violated. But if you don't know these things, you can't use them. So one of the biggest things I can tell you guys is don't try to memorize every single thing. You will not do it. You will fail. All you need to understand is that if you are in a scenario or a legal event and you think it's gone on a little too long or certain things, question it, challenge it, research it. At least now you are aware that you can. And knowing is half the battle. All right, guys, I'll talk to you later. Enjoy the day. Go do something fun, exciting, new, adventurous, but not that's going to get you in any trouble as a belligerent or combatant. Once again, everything here is education, entertainment. Appreciate each and every one of you. Talk to you guys later.